Do you have a U.S. citizen son or daughter who is 21 years old or older and wants to petition you? Hi, my name is Alina Ray Conrad and I'm an immigration attorney. I help families stay together in the United States. The petition is the first step in a permanent residency case, and it establishes the relationship between the U.S. citizen or permanent resident and the person they are wishing to petition. However, the petition is just the first step. An immigration attorney needs to determine if the applicant can do all of the process here in the United States, which is called adjustment of status, or whether the person can start most of the process here in the United States, but then it needs an interview in their home country. This is a very important determination to make because these are two completely different types of cases. They take different amounts of time, the fees are different, and also the type of proof that needs to be submitted with each is very different as well. It's also important for an immigration attorney to determine if the parent is going to need a waiver. There are different types of waivers. The most common one is a waiver because the person entered undocumented or entered legally but then accumulated what's called unlawful presence and needs a waiver for that. This is a very important determination that an immigration attorney should make because they need to look at each and every entry and exit to the United States. It's a common misunderstanding that only the last entry matters, but immigration is going to look at all of them. If the parent needs a waiver, then the parent needs to have a spouse or a parent who's a U.S. citizen or permanent resident. And there needs to be proof that that person is going to suffer what's called extreme hardship if they can't be here in the United States. Unfortunately, USCIS does not consider the hardship to a U.S. citizen child. So if you have a U.S. citizen son or daughter who's 21 years old or older, yes, they can petition you. However, the petition is just the first step. And if you need a waiver, then the U.S. citizen child is not going to be able to help you with that. You have to have a parent or a spouse who is a U.S. citizen or a permanent resident. If you have DACA and were able to get an advanced parole approval, and so your last entry is legal, and now you have a U.S. citizen son or daughter who's 21 years old or older, they might be able to help you get your permanent residency. It is important for an immigration attorney to review all of your entries and exits to the United States. It's not just the last entry that matters. So the fact that your last entry was legal on advanced parole is great. However, immigration is going to look at your entire immigration history, not just the last entry. Also, there are other types of waivers that are sometimes needed, such as for misrepresentation or for certain criminal convictions. So if you have a U.S. citizen son or daughter who's 21 years old or older, and you're wanting to find out if they can help you get your permanent residency, give us a call or send us a message to schedule a consultation. At the consultation, I will go over your entire immigration history and criminal history and talk about any petitions or applications that have been filed, and I'll find out your options. Take care.